Good morning, and thank you for joining us today, Thursday, January 20th, for our webinar entitled PAGA Lawsuits and Why Your Company is at Risk, presented by Ethos Human Capital Solutions and Merhab, Robinson, and Clarkson Law Corporation. My name is Denise Keddy, and I am your moderator for this session. A couple of quick housekeeping notes before I introduce today's topic and our expert panel. The webinar is being recorded and all attendees are in listen-only mode. The webinar will run approximately 60 minutes in total and is being recorded. The webinar will be available on both the Ethos, HCS, and Merhab, Robinson, and Clarkson YouTube channels in the next day or so if you'd like to see a repeat of the webinar. Please take a moment now to visit the handouts area on your dashboard to download a copy of today's presentation. To access the handouts area, click View on your menu bar and make sure you have checkmarked the handouts and the Q&A area to access the presentation. If you have any questions during the presentation, please post them in the Q&A area on the dashboard at any time during the presentation. If you would like your question directed to a specific panelist, please add that information when you send in your question. Just a reminder that today's webinar is being recorded and all accompanying materials are protected by copyright. Please note that this webinar is for educational purposes only and should not be construed as legal advice. We recommend that you speak to your professional advisors about the specifics of your business. And again, the information offered today is in the webinar today is as of January 20th, 2022. As I mentioned, our topic today is PAGA lawsuits. Let me introduce you to our panel. Our legal expert today is Curtis Urian, associate at the law firm of Merhab, Robinson, and Clarkson Law Corporation. He works in the firm's transactional department where Curtis advises clients in real estate, finance, business succession planning, corporate, and employment law. In addition to his work with the firm, Curtis has contributed articles to law journals and as a part-time lecturer in the Business and Political Science Department of the American Jewish University in Los Angeles. He has been also recognized by superlawyers.com as a rising star in Southern California for multiple years. Our next presenter and host is Linda Duffy, president and founder of Ethos Human Capital Solutions. Linda has over 30 years of executive human capital experience and is known as the people problem solver. Linda and her team at Ethos are known for building the magic of the human connection with a unique approach to HR consulting, recruiting, training, and payroll support programs. The Ethos team works with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization so that you, as business owners, can focus on running your business and achieving your goals. Linda, could you introduce our guest speaker today and also talk about HRCI credit?
I absolutely can, Denise. Thank you and welcome, everybody. Before I introduce Sean, our guest today, usually we submit requests to get HRCI credits, and my bad, we were a little bit slow in getting that done because it's required like a month ahead of time. So for those of you on the call today that usually ask for HRCI credits, just know that you can always go in on the HRCI or SHRM platform and enter your attendance at this webinar. The only thing that you won't have is like the 6-digit code that automatically populates all the information. So you can still ask for credit. We don't have the code for you, so just know that. But you would still be able to get 1 hour of credit for today's session. Okay, housekeeping aside, I'm super excited to have Sean Larson returning with us. Sean is a principal with Larson and Nador. He has actually attended or presented our webinar before. Sean is the founding partner along with Joe Nador, and they represent employers. So Sean's here today because unfortunately, or fortunately, depending how you want to look at it, he has expertise in PAGA matters. He also handles the litigation that's employment related for Curtis's firm, so they have worked together before as well. So Sean, thank you so much for being here today. We're very excited to have your expertise and look forward to hearing what you have to say. Okay,
thanks, Linda. Always a pleasure to be here.
Thank you. So in terms of our agenda, pretty short and simple. So we're going to do a quick overview and then talk about what PAGA is and and types of PAGA claims. Some people on this webinar may not be familiar with PAGA, so we'll give you a quick overview, but then we're going to get into the meat of it because we really want to hear from Sean sort of what this is about and how this whole process works. There's been a study of some past claims, so we're going to share that with you, talk about damages, recovery, what you need to know because it's pretty expensive pretty quickly when there's a PAGA claim. And then we'll also talk about some more preventative things like what you can do so you don't have this happen in the future. All right, so Curtis, why don't you start us off by talking about PAGA, what it is, give us a little bit of overview. And why don't you unmute yourself first so we can hear you?
That's a great idea, Linda. Thank you so much for the introduction, and to Denise for the introduction as well. And thank you, Sean, for joining us. Sean is, like Linda said, my firm relies on Sean and his firm for litigation defense for employers. And would like to lean on Sean as much as possible as an expert in PAGA here. But just as a general introduction and explanation of what PAGA is. So PAGA stands for the Private Attorneys General Act of 2004. So what PAGA basically does is it deputizes private citizens, employers. What PAGA does is it deputizes private employees of employers to sue their employers on behalf of the government. So when you think of labor code violations, there's really two types of penalties that are imposed, penalties that are paid to the employees and penalties that the state can sue the employer and collect. So what PAGA does is it empowers employees to represent the state to sue the employer for all of the civil penalties that an employer can recover. PAGA is a private right of action, and so it's maintained just like a civil lawsuit, just like any other civil lawsuit. And it has employees working as agents or proxies on behalf of the local California Labor Workforce Development Agency. And when the civil penalties are imposed or settled, to incentivize the employees to act as proxies or agents or representatives of the state government, 25% of the PAGA fees go to the employees, and 75% of the penalties collected go to the state, go to the local workforce development agency.
Awesome. Thanks, Curtis. And we're getting a little bit of an echo when you're speaking, so I don't know if you need to like unplug your headset and try again or what, but we're hearing you and I think you're hearing you, so it's causing a little bit of a distraction there. Let me talk a little bit just the history of PAGA. So this has been in effect now, I can't believe it's been this long, but since January of 2004. There have been some bills along the way, as you can see here, that were introduced. It also is a really good indicator of who has a strong lobby because there's been a couple of industries, like the construction industry, for example, janitorial workers. They are exempted from PAGA, but you can also see that there was a bill introduced back in 2017 that was an attempt to allow employers to cure an alleged violation before the action was filed, and that bill died. So it's like, the workers, the plaintiffs' attorneys, those guys have pretty strong unions, but not so much for the employers, I guess, when it comes to California legislature. Sean, you want to tell us about different types of PAGA claims?
Yeah, you bet, Linda. And I guess just before we get there, talking about this history and the backdrop of PAGA, it's interesting. The way we used to talk about PAGA when it was in the first couple of years was this idea of it being a bounty hunter law, because they're sort of quasi-class actions. But the idea is you're allowing this employee to step into the shoes of the state. And so not only on their behalf, but on as a representative of a whole bunch of employees. And we'll kind of get into the meat of that a little bit as we go along. But that's sort of a lead into what sorts of the types of PAGA claims that you can have. I mean, essentially, PAGA claims come up in a whole bunch of ways. Primarily, and quite frankly, nearly exclusively, the way that I see them is in wage and hour law. But that's not the only way they can come up. But honestly, that's probably the most profitable for the plaintiffs' attorneys who bring these cases. But that said, I mean, you see in the slide here, they come up in a couple of ways. Number one, violations of the California Labor Code that are specifically listed in the statute. That's everything, as we'll talk about in a minute, from rest and meal break to overtime to failure to pay wages in a timely manner, et cetera, et cetera. Can also be violations of California's health and safety regulations, right? We'll get into that in just a second here. And then any other violation of California's labor law. Essentially, if it's in the labor code, there is now a way to sue for it, where there might not have been a private right of action beforehand. Any rights to seek a remedy on behalf of employees rested only with the state. Those now essentially are all in the hands of plaintiffs, and more specifically plaintiffs' attorneys who can bring those sorts of claims. I mean, you potentially spin this all the way up to COVID-19 claims, but like I say, the vast majority that I work with and see are wage and hour sorts of claims.
Yeah, and this form actually, I mean, I cut and pasted it a little bit, but this was actually taken from the Labor Commissioner's website, right? So the employees, like everything now is so easy for the employees, right? They go on and they just have to check however many boxes apply. But you'll notice on the right-hand side, for example, about halfway down, it says occupational safety and health. And it just says like, here's the labor code sections, but it means like the entire code for occupational safety and health, right? Like, so like you said, for COVID, for other things. So I think, Curtis, you said yesterday, it can pretty much be anything in the labor code, but there was like one caveat. You want to talk about that?
Yeah, so there are some statutory exemptions for PAGA, but they're very narrow and we don't see them come up very often. It's most of the time we see PAGA claims for what's listed here: wage and hour, unpaid reimbursement, improper deductions, travel time that wasn't paid, things like that.
Right. So it can be just about anything. It can be, you didn't give people their paid sick days, misclassification is always a big one, right? So it could be just about anything, not having a written COVID plan. Or I was reading about one case where an employee had to get her temperature checked and alleged that that was taking too much time and it was compensable time. I mean, it can be almost anything. And that can add up quickly, right? So Sean, why don't you walk us through like how this actually works from a logistics standpoint?
You bet. And I was just going to say, looking at these types of claims, it's interesting. Like I said, the bread and butter is essentially, run-of-the-mill wage and hour stuff. But like any employment, employment law runs on trends a lot of times. And so even before PAGA, what we would see are plaintiffs' attorneys bringing all sorts of new sorts of cases, and then we'd see a rush of those cases, and then they'd go away. So I imagine that at some point we're going to see plaintiffs' attorneys getting more adventurous in the ways that they use PAGA, right? That they realize, well, wait a minute, if I branch out just beyond my sort of cookie cutter wage and hour claim, there's this whole world of potential PAGA claims available to me. And I think all it will take is a couple of clever plaintiffs' attorneys, or ones who are willing to take a flyer on a couple of cases and get a couple of settlements before we see that trend come up. So I wouldn't be surprised in the next couple of years we see new boxes on this list that we're looking at getting checked. All right, so I'm on the next slide here then, correct, Linda? So filing a PAGA action. So it's interesting. So PAGA, like I said, is a quasi-class action. In a sense, and if any of you do class actions, you know that in both state and federal law, there's no preliminary sort of technical or administrative requirements. You simply file them, and you've got to show the court that you can, after taking a whole lot of information or discovery, that the claims are common enough that you can proceed as a class. PAGA is a little bit different. What they've got to do up front is they've got to notify the state. More specifically, the acronym is LWDA, or the Labor and Workforce Development Agency. It's a California state agency. And the employee, or more generally what their attorney, will write a letter notifying the state that they have all these potential claims. It essentially reads like a demand letter or almost a draft complaint in the lawsuit that says, hey, I worked here. Here are all the potential claims I think I have pursuant to PAGA for violations of the labor code or whatever it may be. They've got to pay a $75 filing fee, which is not a whole lot to get these gigantic cases started. They file it online and they send a notice to the employer by certified mail. That's 9 times out of 10 how the employer is first going to find out that this big potential boogeyman is stalking them, right? So those are notice requirements. If the employee doesn't do that, that's an argument that the case should be thrown out to begin with. They haven't met their administrative notice requirements to begin with. Okay, and then you get into this weird period where there's an administrative remedy available. The state, the LWDA, has, I believe it's 65 days in which they can take action on a PAGA complaint. They can under the statute, they can, if they want, investigate, assess penalties, seek remedies, all that sort of good stuff. And after that time period has elapsed, only then can an employee and his counsel file a private right of action, file the lawsuit. In my experience, I've never had that come up, and I'd be interested whether, I think Curtis probably has the same, but he can speak to that, which is, I'm a litigator, but I'm not aware of any instance in which, I know it happens, in which the LWDA decides to sort of wake up and act on its own. Usually, these things sit, you just wait out the clock, and then boom, the lawsuit shows up. So that's sort of the way that's going to work. You wait for that time period to run out, and then it moves on. The life cycle of a PAGA. Oh, good. I'm talking
No,
about
I was just going to ask you a question. So
yeah,
is it sort of like checking the box to get the right to sue letter? Is it the same?
That's a great analog, Linda. It is in the sense, well, it's yes and no. That's the most lawyerly answer in the world, right, Linda? Yes and a no, as wishy-washy as possible. Yes, in the sense that you do have to go through this administrative hurdle, and if you don't, your case is going to be done with up front. However, unlike the filing with the Department of Fair Employment and Housing for a, let's say, discrimination case, in those cases, the lawyer or the plaintiff has the automatic option to just check the box and say, don't investigate, give me a right to sue letter now, and the same day you've got a right to sue letter and you can file the lawsuit tomorrow.
Right.
PAGA is different in that you don't have that out. You have to wait the 65 days for the state. But honestly, the result is going to be the same. It's going to be a lawsuit 9 times out of 10.
Got it.
Okay, then I just kind of walk through this a little bit. So, like I said, it's like a quasi-class action. One of the reasons that these are more appetizing to a plaintiff's counsel potentially is that, like I said, there's no requirement that a plaintiff is going to have to show that they can proceed as a class. Like I say, in a class action, a true class action, they're going to have to make a motion to the court and show with evidence that, hey, these claims are common. This is the most effective way to do this, that this class representative is typical of the class. And that can be a high burden to meet, and it's a lot of litigation and cost. In a PAGA case, none of that matters. You don't have to do that. There's no hurdles like that. It's just simply, are these folks, quote unquote, aggrieved employees? It's a much lower way to get through it. And which is why that leads to the next slide, the next bullet point on here, which is mediation, and trial is all the way at the bottom. These cases, in my experience, and Curtis can speak to his as well, is all of them settle at some point, because it's a fairly low bar for plaintiffs. They're high cost cases, and as we'll talk about in a minute, there's a lot of potential liability that an employer faces. So it makes a lot of sense to mediate these cases. In fact, right now, good PAGA mediators are booking 6 to 8 to 9 and 10 months out. They're so busy with these cases. And the way that you'll generally do that, the life cycle is plaintiff will ask for your discovery, which is what they'll want all of your pay records and all of your time records for the applicable PAGA period. And your PAGA period, the time at issue is going to be 1 year back from the date on which the letter was sent to the LWDA. So essentially, it's 1 year back from the notice given to the employee. That's the period. 1 year back to present. And what the parties will 9 times out of 10 do is agree to a sampling of discovery. You'll agree to give 10% time records and payroll records for 10% or 25% of your class. And based on that, the parties will extrapolate what they think the rest of the payroll and time records look like, and you'll go to mediation. And you'll desperately try to settle the case at a very steep discount, because otherwise discovery is going to entitle them to all of your pay records and all of your time records for that period, which is a gigantic undertaking a lot of times. Bullet point is the trial. This is really interesting. I was just telling Linda and Curtis this before we jumped on the call. In my experience, like 0.1% of these cases go to trial because they're so big and unwieldy and expensive. I had the opportunity to sit in on a continuing education meeting probably 8 months ago, maybe even a year ago now, with all of the judges of the Orange County Complex panel. They're the ones who handle all these cases here in Orange County. And the moderator had a whole series of questions about how they manage, what their procedures are for managing a trial in a PAGA action. And it was really interesting because all of the judge's answers sort of caught her a little bit flat-footed, because all but one of them said, we haven't even tried one of these cases in the past 3 or 4 years, because they all settled. I think only one of them had tried a PAGA case in the last several years, and it was sort of an anomaly. So trial is, employment cases in my experience are, very few of them go to trial to begin with. These PAGA cases are even fewer, simply because of the cost and the potential liability involved. So your real money is in, your real efforts are in the finding some discovery and seeing whether you can mediate these cases.
Makes a lot of sense. And I also, the other option here is arbitration, you would think, right?
Yep.
But Curtis, we repurposed a slide from our new laws webinar from December. You want to talk about arbitration? I think Curtis is having some technical difficulties today, so maybe Sean, you can start.
I'm here, Linda.
Oh, there you go.
I apologize. I'm here. I keep forgetting to hit that unmute button. I apologize. So the concept here is that an arbitration agreement is between the employer and the employee. It's an agreement to resolve disputes between the employer and the employee in arbitration. The idea behind a PAGA action is that the employee is representing, or as a representative of the state, trying to collect civil penalties that the state would be owed. So the courts have held that because a PAGA claim is really an action by the state, and the state is not a party to the employee arbitration agreement, that the state cannot be bound by the arbitration agreement because it's not a party to it. So arbitration agreements must exclude PAGA claims. And if an arbitration agreement tries to include PAGA claims, that part will be unenforceable. And it might even speak to the contract of the enforceability to the arbitration agreement as a whole. So when we draft arbitration agreements, we are very specific, and we expressly state that PAGA claims are not included in arbitration.
That's really.
And I'm sorry, Lynn, I was going to say, if I could jump in for 1 second, if you don't mind.
Of course.
That's great advice from Curtis. It's really interesting. This is one of those places that defense lawyers for the last decade have been, or even longer than that, I guess we go back to 2004, right? Have been fighting this every way they can, trying to find some new loophole or some new argument that maybe some piece of a PAGA claim could be arbitrated, and it's a losing battle. It's really fun to be, for employers at least, the law is only getting worse on this subject. I mean, it's very clear at this point, you can't arbitrate PAGA claims. And so what happens sometimes is you get into these weird situations in which a plaintiff will file a claim for their individual damages or their other individual claims plus a PAGA claim attached to it. And so what will happen is the court will split the case. And what they'll do is they'll say, well, the plaintiff's individual claims can proceed in arbitration, but the PAGA claims cannot. So they're going to proceed here. And what will normally happen, or hopefully usually happen, is that the court will stay the individual claims while the PAGA case goes forward, or vice versa. But I've also seen cases in which the court says, well, we're not staying anything. So you're going to be proceeding in sort of two separate lawsuits, one in arbitration, one in court, against this same plaintiff on separate but arguably related grounds. So it can be a real mess.
Yeah, and you mentioned a little while ago about, how many claims that you've seen or how many PAGA cases you've seen. Clearly people are filing them, right? I'm surprised the number's not larger, to be honest with you. So
Yep.
this slide was taken from a study that was done by Baker and Welsh. You can see that note at the bottom there. Christine Baker was a director for the Department of Industrial Relations for 11 years, and she filed what's called a Public Request Act for all data on PAGA cases. And so this was from fiscal year 2016-2017, because the year is not a calendar year. And this is through July, I think, of July of 2021. And so this was based on the number of cases and settlements filed with the courts. And what her conclusion was, there's an average of 5,200 cases per year. Now, what's interesting about these cases, when you start breaking everything down, is they also did a comparison between the cases that were actually decided by the LWDA versus the number of PAGA court cases. And I think, Sean, you were saying before, like, you don't know of any cases that were decided by the LWDA. They seem like they just waited out, and then the case goes forward in court.
Yeah, that I thought I was just as fascinated by these slides as anybody else. I thought they were, for two reasons. One, just like you said, Linda, I thought the numbers would be even higher. And two, yeah, none of my clients have ever had one with the LWDA pursued. So like I said,
Right.
I know they exist, but I just haven't run into them. So
yeah, I think Curtis said the same thing. I haven't seen one. I mean, we end up with the court cases every once in a while, but that's about it. But you can see that there's a dramatic difference about how long it takes, right, between if the LWDA decides the case and PAGA court cases. And then here's some additional information comparing the two. Is there anything on here that jumps out at either one of you guys?
yeah, I mean, for me, the big factor is the attorney's fees. I mean, right? Like, you wonder, why are people filing these lawsuits? Oh, it's because attorneys make money on filing these lawsuits. I mean, that's the answer to all of these questions usually. And I apologize, that's the opinion of a jaded old defense lawyer, I know. But that to me seems to be the real value in these cases. And you wonder, you wonder, why would people bring these cases if they have to give, as Curtis told us about before, if they have to give a chunk of it over to the state, they don't even get to keep the whole remedy. As we'll see below, it's because the number can get so high so quickly that it still makes financial sense for a plaintiff's attorney to chase one of these cases. So, and
for the attorney, but what about for the employee? Because look at the average reward per employee.
Linda, are you trying to suggest to me, a defense lawyer, that maybe an employment case is not brought for the best benefit of an employee? I don't know that I can sign on to that. Huh? No, you're right.
I'll sign on to that.
Yeah.
So, Sean,
but you're right. Go ahead. I'm sorry.
Well, I was going to say, one of the things that I was reading about in preparing for this is how, there's a settlement, but somehow it's not just a straight 25-75 split, right? It's like the attorney's fees are coming out, or only a portion of the case is actually sort of considered to be PAGA.
Yep.
So how does that work?
Yeah, settling. So it's really interesting. PAGA settlements are an art form unto themselves, and they can go a lot of different ways, because there's a little bit of Wild West element to them, because you've got a lot of things at play. Number one, you've got the PAGA case, but what will happen a lot of times is, unlike in a regular old class action, there's going to be always included in the settlement agreement a kicker for the plaintiff, some extra money for going out on a limb and being the representative, and that's just sort of an understood thing. Where in PAGA, that's not really built in, but plaintiff's counsel are usually going to insist on that, but will do it through some other means. So, for example, I've had in a couple of cases where they'll say, we're going to settle the PAGA claim, but we're also going to carve out some of that money and call it a settlement for any individual claims the person may be, thereby making sure that that person gets additional monies that kind of look like the equivalent of a kicker or a premium in a class action, which wouldn't otherwise exist. Or just like you say, Linda, there you're trying to finagle what claims are and aren't released, and that can just get real complicated. It's going to be pretty fact specific based on what you can do. Defense counsel is always going to push for, one payment resolves everything, no matter how you split it up. On the plaintiff side, we don't care. But I've had plaintiffs counsel take that same position, which is we're going to, carve out some of these claims as being released but not released. This is one of those cases. It's, you can't just, unlike a regular old discrimination or a wrongful term case, you can't just sort of slap the same settlement agreement on it. There's a lot of play in the joints as to what does and doesn't get settled and what does and doesn't get paid.
Right. And are attorneys' fees above and beyond, or they come out of the 75-25 split?
Great question. Great question. So what will happen is, the way to think about it is a pile of money. 75% of it just disappears and goes to the state. Out of that 25, that's your gross settlement fund, is the way to think about it. And out of that, you got to make sure you write the agreement this way. But the way it will work is, out of that 25 are going to come a couple of things. One is going to come all the administration fees. So you're going to have to pay a third party to help you find everybody and mail their checks to them. Two is going to come out of that any quote unquote individual settlement like we talked about. Three, also out of that gross amount, is going to come attorney's fees. And then once all of that's taken out, whatever piece of that little pile of money is left, you're going to then distribute out to your affected employees. And so there's not, defense counsel is going to agree to pay one amount, and then it gets carved up lots of different ways. But yeah, attorney's fees would come out of that. And that's what happens a lot of times is, by the time you're done carving up all the money, employees are getting a check for, $3.49 or something along those lines.
Well, that's how you go from 1.1 million, total case amount down to $1,200 for the employee, right?
100%. 100%.
Which is still so interesting to me on why somebody would go that route. So another part, so the firm that did that study did in conjunction with this PAGA Foundation. And so they had some other statistics. And so they actually, on this website, you can go county by county in California, because this is a unique California law. Do you know if any other states, Sean or Curtis, that have a PAGA law like this? Because I don't know of any.
None for me. I've not run into any.
Yeah, I mean,
I can't think of anything either.
Yeah, I think we're lucky. Woohoo! California #1.
Congratulations.
Yeah, congratulations. We're the only ones. But I was going to say, you can actually click on any county and it'll tell you the statistics for the county. So I just pulled up Orange County and Los Angeles County. Believe me, the most people on this call are going to be from these counties. So you can see where we're actually surprised that the settlement's pretty much the same. Like the numbers are pretty similar, when usually, like for regular court cases, the Los Angeles County, tell us, well, I'll just ask you, Sean, so how are the verdicts usually different in regular lawsuit, employment related, that's between Orange County and Los Angeles?
I'll put it this way. I've got a really good friend who's a plaintiff's counsel, and he practices in Orange County in LA, and he has been shifting his practice over the last couple of years to take as many LA cases as possible. Right. And what he told me, this is a quote from him, he said, LA is just like an ATM at this point. So
oh, nice.
It's rough. It's rough going up there for employment cases on the defense side.
Yeah, and the other county I looked at, just out of curiosity, was San Francisco County. Their average settlement is 2.1 or almost 2.2 million. So that's almost twice as what it is down in Southern California. So, and the attorney's fees, twice as much as well. So Sean, let's now scare everybody if they weren't already scared, because this is where it gets a little crazy, right? When you start figuring out how you're going to just keep adding the cha-ching, cha-ching, cha-ching on these type of claims.
Yeah, and so it's always funny. I always feel like in these presentations, I'm a little bit of a little black cloud, telling people all the reasons they should be scared about things. But this is, as you say, Linda, this is a great this is a reason to keep in mind why these cases keep getting brought up. So what's interesting is another way that these cases are different than regular old class actions. Regular old class actions are usually by employee, or work weeks is the calculation you put together. However, PAGA is a little bit different. That the numbers are calculated by every pay period. Now, if a company pays every 2 weeks, it's really, the difference is negligible. But I've got clients who pay on a weekly basis, and if you're paying on a weekly basis as opposed to every 2 weeks, you just by that measure alone are potentially doubling your liability under PAGA from a regular old class action, just because you've doubled the number of pay periods as opposed to work weeks, which can be real scary real fast. So as Linda mentioned before, so the way this works is, you're not seeking damages in these cases. So it doesn't really matter. You're not calculating everybody's hours to count minutes to see how much they're entitled to in double time or time and a half, like you would in a wage and hour case. These are civil penalties that are fixed. And the default, unless the individual violation has a separate measure, is $100 per initial violation per employee per pay period. And then for each subsequent violation, it's $200 per employee per pay period. So imagine your worst case scenario is you've got, across your workforce, you have sort of system-wide problems. So for example, you're using a rounding policy on your time clock that everybody's missing a couple of minutes here or there. Or you're not, you're clocking meal and rest break wrong, or even worse, your paycheck is wrong across the board in every single place. What that means is you've got, you're multiplying violation upon violation upon violation by pay period by employee. It can get to be a big astronomical number pretty quick. One of the things that we argue about a lot, again, the context is mediation 9 times out of 10 as opposed to trial, is there's law on both sides of this. The question is, well, wait a minute. If I'm an employee, per pay period, can I have a violation for rest periods, and a violation for meal periods, and a violation for missed overtime, and a violation for my paycheck being wrong? That's what on my side of the fence, we refer to that as stacking. Plaintiff would more generously call it just multiple penalties, an accrual of multiple penalties, but the way we look at it is stacking. There's law on both sides of that, but generally the trend in my experience has been that, especially in mediation, that settlements don't allow for stacking or for multiple penalties, which is a good thing. How a court would look on that if it were to go to trial, the plaintiff's entitlement to that is maybe a more of an open question. But generally, for purposes of resolving a case, you're going to focus on one violation per employee per period, and for purposes of settling it, you're going to ratchet it down to just $100. You're not going to futz around with multiplying that to 200. That can still be a gigantic number, as we're going to look at in a minute. And I think we already talked about 75% going to the state, but that's sort of the way this PAGA stuff adds up real fast.
Real fast, right? So let's take a look at a couple of examples. So on the left, let's just assume small business, 10 employees, you're paying semi-monthly, so you have 24 pay periods, right? And you have a meal and rest period violation. Maybe, again, not clocking out by the end of your 5th hour, not paying, a meal period premium, like all sorts of different meal and rest period violations, right? You're combining them all together, like whatever it is, I've seen it all. That gets up to $47,000 real quickly, because as Sean mentioned, it's, $100 for the first pay period, right? But if you have 24 pay periods and this has gone on for a year, and Sean, can these go back 4 years?
1 year. You go back 1 year from the date, 1 year from the notice. Yep.
Okay, so a little bit different from other types of claims. So 1 year, so if you've paid 24 pay periods, right, it's going to be $1,000 for that first pay period, 10 employees times $100, right? But then for the next 23 pay periods, it's $200 per pay period, right? So we jump from that one mistake, for one pay period, $1,000 up to $46,000 for the next 23, right? So $47,000 for that one violation. And then, if if the person's being paid weekly, it's more than doubled, as Sean mentioned. And then here's another one, just to do another quick math. Let's say you have 50 employees and you're not factoring in a bonus into the regular rate calculation for overtime pay and sick pay and meal period premiums. And that's $235,000 of PAGA exposure over that 24 pay periods. And then, Sean, as you were mentioning, you guys argue about this, but potentially it could be doubled or tripled, because that would also mean you have incorrect wage statements. If somebody left, you didn't pay their wages upon termination in a timely manner. Like, it stacks up really fast.
Yep.
So let's take a look at more positive things. So, we would obviously, and I think Sean knows this attorney also, he says, spend 30 minutes with me now or 30 hours with me later. Take preventative action, spend the money up front, spend the time actually looking at this and auditing, especially your timekeeping and payroll practices, because as Sean said, that's the majority of the types of claims that he sees. If you're using a rounding policy, Curtis and I just told you last month, stop doing it basically. Like, just, there's no good that's going to come from that. Definitely don't do it on meal periods, but even if you round at the beginning and the end of the day, you're setting yourself up, in my opinion. If you're automatically deducting time for a meal period, again, it's going to be a problem for you. If you're not paying meal and rest period premiums, people are starting their lunches late, or they're not having an uninterrupted 30 minutes, that's going to be a problem. Make sure you're using the regular rate calculation for overtime pay and sick leave and meal period premiums. If you don't know what that is, you need to find out. Make sure that all the required information is on your wage statements. I know, Curtis, you've said before that, you've run into this where there's, they didn't put the period after the ink, or it's an LLC, but they have ink on the wage statements or something. There's a little thing that's off. And for each one of those wage statements, that's $100 for that first violation and $200 for every subsequent one. Maybe you put in an alternative work week. You've got people working 4 10-hour days, but you didn't do it the right way. You didn't do the secret ballot. You didn't file it with the state. That's going to be a violation. And also make sure your payroll company is in compliance. Like, Sean, we were just having a conversation about this the other day, I think, right? Where a mistake was made, by a 3-lettered payroll company, right?
Yeah, it's it's a PAGA case we settled. And the employee, it was really interesting. It was a great mediator, good counsel. It went about as well as you could do. And the mediator, who has years and years and years of experience, said to the client, all these policies look great. You did a great job on policies. You're doing things the right way. Here's the problem. And we were looking at it, and what had happened is the payroll company, the to be unnamed payroll company, the company was giving the hours and reporting them the right way to the payroll company. The payroll company was miscalculating to the tune of about 10 to 12 cents the overtime rate. And it's a thing, if you're relying on your payroll company, that's not a thing most employers are going to go back on a week-to-week basis or ever really to double check that calculation. That's why you hire a payroll company to do that for you. But
right.
That's on paper. So you essentially have no argument around that, right? It's in paper, in writing. You've screwed this up. You didn't pay them, violation. Your paycheck's wrong, violation. So it was unbelievable.
Right. And the problem is you can't go back after the payroll company because you signed something, right, saying that you're going to indemnify them instead of the other way around. And, you're still at the end of the day responsible for your employees' pay and it being correct. So that's a problem for sure. I had a similar situation with a unique pay type, let's just say this, where we had to calculate the regular rate of pay for overtime purposes. And we actually created a spreadsheet for the client, and then we calculated ourselves. Then we put it into the payroll company system to make sure that it was coming out the same way, because I knew that my spreadsheet was correct, but I didn't trust that the payroll company was getting it correct. And thankfully they were in that instance, but it's important that you check that. The other thing.
I'm sorry to interrupt you. And I'd say the more complicated, so sometimes employers, I get clients who make their compensation system, they sort of overthink it and make it a little more complicated than they need to. And just like you were saying, any level of complexity that a client uses with their compensation just means you got to double or triple the amount of oversight you have over it and over your payroll company.
Yeah, and I personally just seen too many payroll companies that don't know how to do the regular rate calculation correctly. And so
Yep.
that's the one, anytime a regular rate's involved, meaning that's, you're paying your employees, an hourly employee, some types of bonuses or commissions or anything like that, some sort of incentive pay. That's when we want to double check that. And then also audit safety practices, right? Do you have a written injury and illness prevention program? Do you have a written COVID prevention plan? Like all of these different things can be violations as well. Curtis, is there anything you wanted to add on this slide? Anything that you're seeing out there?
I just wanted to echo and chime in here that the PAGA does not take into account the employer's intent. It does not take into account actual harm or damages to an employee. If it's a technical violation, it's strict liability from a PAGA perspective. And there are, the labor code is expansive and it has many requirements. And an employer might technically violate a section of the labor code that doesn't have a corresponding penalty or damage. And in those cases, the PAGA law says that if there's no damage or if there's no penalty stated in the labor code section, that the default penalty will be PAGA penalties.
Great. Okay, so steps to take after receiving a PAGA notice. First and foremost, contact legal counsel, right? So you want to reach out to Curtis or Sean or whoever your employment attorney is and make sure that they know about it right away. And then the rest of this, Sean, like what do you usually advise your clients to do?
Yeah, that's great. I mean, step 0.5 is to, bury your head in the pillow and scream in frustration, because I'm sure, every client I have who gets one of these things, it's the most frustrating thing in the world, right? Yeah, so it's going to depend on how, on the facts of the case, but as a general rule, the very first thing I ask, or if we get Linda involved or an expert in the field, is to get in and figure out, is this claim right? I mean, does this plaintiff have anything to say? Are we doing our payroll wrong, or are we doing our rest breaks wrong? And sometimes, depending on the size of the organization or the extent to which policies are in writing, that sort of stuff, that can be relatively simple. Or if you've got a big organization, there are experts. You can hire an outside expert whose whole job is to come in and perform essentially a forensic audit of, you turn over to them a big gigantic pile of payroll and time records, and they'll do a real specific analysis for you. But that can get expensive. But at a base level, just like Linda says, you want to get in there and do your own investigation. And let's say that you figure out, hey, wait a minute, we have been doing our breaks wrong. Or wait a minute, payroll company has been screwing up. I didn't mean to say that. I apologize. Payroll company has been screwing this up. You want to fix it. And I'll tell you why, because you want to cut off liability. Remember, it's from a year back ongoing. And so if you can stop the bleeding now, you want to do that. But to be clear, you don't want to do that without talking to your HR expert and or your counsel before doing it. Because what I've seen happen sometimes is employers will often make a change on their own, and they'll fix the immediate problem, but also at the same time created a brand new problem for themselves. So you just want to be real clear that you're doing it the right way, and you're just bringing some expert help to help you do that. And then the next step is really, like Curtis wisely said, this is akin to strict liability. So there's some argument about have you done it the right way, or is there something here? But a lot of this is just math. And you sit down, you figure out, you run some spreadsheets, and you talk about what your potential liability is, how you can minimize that. And 9 times out of 10, you're going to want to start having discussions about how you get the case resolved before you spend thousands and thousands and thousands of dollars in legal fees fighting about it. So it warrants a lot of attention early. PAGA cases are ones that you want to deal with early.
Absolutely. Now, an employer still has to cure the violation, right? I mean, if there is one, so you don't want to wait to do that.
Yep.
You don't want to wait to settle the claim before you do that, because it just is continuing to add up as time goes. Yeah. Great. So there's obviously a lot of problems with this PAGA law from my perspective, and I'm sure Curtis and Sean, I can speak for you on that one as well. You know, as Curtis mentioned, there's no requirement under PAGA that an employee actually suffers harm, right? Doesn't matter if your intent or the extent of any harm, so that's a problem. It also, remember, it applies to all employers. Small employers don't get a pass on this, right? You're expected to play by the same rules. It applies to nonprofits. It applies to every employer. So you can have a violation with one employee or with thousands of employees. It's just a matter of dollars. I was speaking to a prospective client a couple of days ago. He's getting ready to write a check for $1.75 million because they had meal and rest period violations. You know, they've got about 250 employees. So, you know, it's going to add up fast. So a few other things in here, you know, like Sean mentioned that this is considered like a representative action, not a class action, but it has sort of the same type of approach, just without the without the hurdles that the plaintiff's attorney has to go through. And there's also what's, you know, some people refer to as abuse of draft PAGA complaints, because they don't even get filed. They just get sent, you know, to the client saying, hey, we're going to file this, which is going to force them into a settlement quickly. And as we also mentioned, you can't waive it. So the good news is that there is something that's being done about it. Cal Chamber and some other industry groups have put together an initiative called the California Fair Pay and Employer Accountability Act. And what they're proposing is an initiative that would go on the November 2022 ballot to be voted on. And it's going to eliminate some of this, and it's also going to hopefully produce faster resolution. So they have I'll let you look it up and read about it, but just be on the lookout for this because it would actually give money to the employees if there was a violation or if there were a violation, and not the state and not the lawyers. It would sort of create a different forum for doing this. So just to be on the lookout for that. With that, Denise, I'm going to turn it back over to you to ask questions.
Okay, great. Thanks so much. Okay, we have a couple questions that came in. During the waiting period, so I think a lot of these questions are going to be directed to Sean, so I should have stated that first. But during the waiting period, does the employer have the ability to settle the claim, the PAGA claim, prior to going to mediation?
That's interesting. You'd be settling with, the answer is yes. I've never had that come up before, but the answer is yes. You'd still probably want to do it via mediation, quite frankly, because that's generally, because these things get so complicated, you do it through there, but there's nothing that would prevent you from doing that.
Okay. Another question: can an employee who moved out of California still file a PAGA claim retroactively? And so that's going to be a two-part question. Can they move out of California, file it retroactively? And then the second part, what if they're no longer working for this California employer anymore?
Great question. So the question of filing, being a plaintiff who lives outside of California, filing in California it's kind of a longer discussion about standing. But let's say as a general rule, if PAGA cases are oftentimes filed by former employees. You don't have to be a current employee. So former employees file them all the time with regard to employment they held with California companies prior. If they've left the state, and you've got, that's kind of a larger question about jurisdiction, but the general answer is, yeah, if you have worked for California, worked in California for a California employer, you've got potential PAGA liability. And quite frankly, let's say if I'm an enterprising plaintiff's attorney, let's say that the person who comes to me says, I've lived outside the state for a long time, and you've got maybe some jurisdiction questions. The smart plaintiff's attorney will say, well, you may not be the right person, but can you give me the name of 5 other people you know who work there? And they'll find somebody.
There's always somebody. Okay. Question: are the monies received by the employee taxable in a PAGA settlement?
Yes, I mean, that's income to them. I'm not a tax expert, but generally what we'll say in a settlement agreement, and Curtis, if you've got any additional thoughts on this, I'd be interested, but generally what we'll say in the settlement agreement is if I'm the defendant and say, hey, we're paying X, you guys are going to split that up for the terms of this, and you're going to be responsible for all of any taxes associated with it. Generally, generally you're not going to withhold on it. You're just going to pay it out and say to the other side, you're going to worry about the taxes on it.
Yeah, and that's usually something we use as kind of use as leverage when we're settling. Is we'll tell the plaintiff that we're going to issue a 1099 for all of the fees going to the plaintiff, and they balk at that because then they know they're going to have to pay taxes, and we just use it as leverage and going back and forth.
Okay, great. I think that's it for our questions today. Linda, do you want to pop up the slide with the contact information?
Absolutely. So thank you everybody for attending today. Here are emails, and you saw early on in the bio slides, you have full contact information there. So if you have any questions, please reach out to any of us and we'll try our best to answer them. If you have suggestions on future webinar topics you'd like to see, please shoot me an email. We'd be happy to do that. Curtis and I try to come up with interesting topics, but we really want to know what you'd like to hear about. So with that, I'm going to say thank you so much, Sean, for joining us today. Really appreciate your expertise. Curtis, as always, it's a pleasure to be with you. And Denise, thanks for moderating. So have a great day, everybody.
Thanks, Linda. Thanks, everybody.
Thanks. Have a great day.